Welcome to the Emerging Lawyer series at the Coffee Conversation Show, powered by the Emerging India Forum TIF and a tech partner, Prime Infotech Solution. Theme is Behind the Bench, the Mind of an Advocate. We have with us Ravi Prakash, advocate on record, Supreme Court of India. With over 12 years of litigation experience, Ravi has mastered the art of navigating complex legal battles, shaping legal education, and contributing to constitutional law discussions on a global scale. But beyond the courtrooms and legal texts, who is Ravi Prakash? What drives his passion for justice? And how does he balance academia, litigation, and life? And friends, he's also a Columbia Law School alumnus. That's impressive. So, a Supreme Court lawyer going to Columbia Law School, that's also very impressive. So, welcome, Ravi Prakash, to today's coffee conversation.
Hello, sir. Good evening. Thank you. Thank you for such a lovely introduction. Uh,
Okay.
and I'm happy to be here on the coffee with you, uh, ready to share my experience of the
Mhm.
litigation and particularly the advocacy journey.
Wow. So let me explain you. There will be three rounds, Ravi. First round professional, second personal, and a surprise rapid fire where uh, you will be in the hot seat and you'll have to be witty, fun, and quick. And here's inspiration, legal AI 101. As everyone is talking about AI. So let's begin. Friend, I'm Lion Amir Virani, host of Coffee Conversation and Legal Tech Evangelist at Prime Infotech Solution, author of 15 books. We help law firms, corporate legal, startup, SMEs, world-class technology, software licensing solutions. So my first question, Ravi, what inspired you to pursue a career in law? And did you always envision yourself in litigation? And how has the journey been?
Uh, Thank you for the question. To begin with, the law was not my first choice after class 12th. However, because I studied in Sainik School, Balachadi, Jamnagar, Gujarat. It's one of the defense school which prepares the students for to join defense forces through NDA, National Defense Academy, Pune. So obviously, my first target was to crack NDA, but due to certain medical emergency and situations which I because of which I could not finally qualify and join the NDA, I chose law as a career option because at that stage, way back in 2005, it was in a very formative stage. The second generation reform was in legal education was taking shape. The new law schools and the new law universities were coming up across the country, and as rightly you must have noticed that I have graduated from Hidayatullah National Law University, Raipur. It was the sixth national law university in the country at that point of time, which started in year 2003, and I joined HNLU in year 2005.
Wow. Okay. So let's continue the conversation, Ravi. Litigation requires resilience. Can you share a moment when you faced a challenging case and how did you navigate it?
Yes, of course, litigation not only requires resilience, but it requires a lot of qualities and a lot of patience also. Because of the inherent weaknesses in the system and particularly the kind of population which and the justice delivery system which we are catering to the billions of population. So yes, it requires a lot of mm, different qualities and more than client who is the real sufferer or who is seeking justice, we are the only one who is representing them before a particular forum and all those. However, before the Supreme Court of India, I will tell you my experience that the remedy is quick. In certain cases, the issues are of such a nature that it requires a prolonged hearing, and due to technical reasons also the cases does not get listed before the Supreme Court before the bench. like there is no completion of service, or even mm, the case is not ready for hearing, and that also that goes on for like years. So it requires patience, it requires resilience. And one of the challenging case which very recently I have won it from the Supreme Court, after it was a service matter which started in 2008, well before I joined the practice of practice before the Supreme Court. And recently the candidate has finally got the employment after 16 years, 16 long years. And it has happened in state of Delhi. It was a the recruitment of teacher in state of Delhi, conduct to be finally done by the municipal corporation of Delhi, because that was an MCD run school. So yes, 16 long years for a eligible candidate to get a job through the courts after 4 round of litigation. Yes, it requires a lot of resilience, it requires a lot of patience, but ultimately the justice was done, and he has already joined this. Yesterday only he visited me again, once again, and yes, so that gives us satisfaction as a one who represent the poor client or the individual or uh, any person before the Supreme Court of India. Ultimately, yes.
Wow. So, Ravi, white collar crime defense is one of your expertise. So, what are the key elements that goes into preparation of a white collar defense?
Yes, as we understand, it's a very newly found area of interest for me, and I will say that I have honed my skill when I was studying my masters from Columbia Law School. There, I understood the subject, and particularly the nature of crime is such that it's transnational. It may happen within the domestic jurisdiction also. It may, because now the because of globalization, there is a lot of investment, there is a lot of uh, flow of money or capital, or even different kinds of uh, practices which are coming up just to get the favorable licensing, favorable uh, twisting in the policies or the framework. Some people say that it's a kind of corruption. Some people have legalized it in the name of licensing, or some people have it depends. So the white collar crime is very interesting. It's a, and particularly the cross border and the transnational aspect of it is very challenging. Yes, it involves certain basic aspects as a criminal defense lawyer. Once you get the, like, when a client approaches you, you know that the investigating authorities or the prosecution authorities are after my client. So once we get into the thick and thin of the skin of it, the investigation, what all documents they are having, we seek documents from the investigating agencies, we prepare defenses, what are the procedural lapses, key procedural lapses, or even for that matter the denial of basic rights which the Constitution of India guarantees, or the procedural irregularity. We work on those loopholes and approach the tribunals. The essence, sometimes we have very different tactics also. Like in United States, people go for plea bargaining and go for a, like, yes, I accept this, let's bargain it, I will pay the compensation, because it's not something, the crime which has happened against the body, it has not happened until unless in United States the national security is being threatened. I think in most of the white collar crimes, people get plea bargaining, and uh, they do the compensation and get offsets, all those crimes. But in India, it's a very different experience, because here the white collar crimes are being investigated by two of the agencies, CBI and ED, and primarily. And in some of the cases it's SFIO, or even the for the corporate crimes, the special agency constituted under the Ministry of Corporate Affairs. So uh, and it's not the plea bargaining in those cases in India. It's the practice is yet to evolve, and a concrete feature has it to come up as it as a feature, regular feature. I think it will take some time, but yes, and simultaneously we lack the policies also, the policy and a comprehensive guidelines, that what will happen in such cases, how the ones who the accused or the companies which are, or even the individuals who are indulging into such white collar crimes should go ahead with the like pleading their guilt, or coming clean, and because they have the approach that the he or she has contributed to the society through the economic means or the economic developments, or by generating the employment, cannot be overlooked, where the employment is employment opportunities are quite uh, less. And so in that sense I will say that the India is an evolving jurisdiction, economic jurisdiction. It's on the path of economic developments. The in such incidents or the economic mismanagement, it's upon even the prosecution agency that how it sees a particular conduct or the business transaction, whether it qualifies as a white collar crime at all. Because in certain cases I see that the it's a very simple, the failure of or the mismanagement of the companies or the corporate transactions. So but the prosecution agencies goes ahead with extraneous consideration after the individual who runs or who manages the business, saying that it's a crime under the PMLA Act, or it's a crime under such and such different legislations. Yes, the if you go on to interpret those expressions and those wordings, the crime will fall into that ambit and that scope. But is it really a crime? That's when the business decisions or the business transactions were taking place, whether it was comprehended as a crime. If understood and intention is proved, then yes, to a certain degree, I will say that but still, I will say that we lack a comprehensive policy to tackle the white collar crimes in India. And it's a very high time because of the growing economic activities, growing inflow of the investment. We have make in India policies and all those things. We are inviting the corporate world or the big corporations from outside to invest in India. And because of the federal nature of polity also, uh, the policies and the regulatory framework differs, because the businesses will not run in isolation. It runs in a particular territorial jurisdictions. It requires so the political stability or the policy framework at the political level, from the whether it is run by a the government is run by a particular political party. My thrust is to eliminate the political biasness or the political angle towards prosecuting the white collar crimes. We should not India should offer a comprehensive, a stable legislative framework and the policy framework at both level. No, not only both level, at the tri level, at the central level, at the state level, and at the local municipality level also. It should offer a very stable framework, legislative and policy framework, so
Okay.
that you minimize the risk of getting those offenses committed. Because and the use of technology will be uh, much welcome in this all these transactions and regulatory, replacing that compliance procedures and the regulatory regime.
Wow. Okay, let's continue conversation. uh, so you have been involved in comparative constitutional law. What are some key takeaways from your research in this field?
Yeah. The constitution is one of the key focus area of my education, and I practice mainly in constitutional law before the Supreme Court of India. I have been involved in various kind of cases where which involves different like interpretation and reinterpretation or reconsideration of the legal propositions relating to the fundamental right. Mainly, I will say focus on the affirmative actions, particularly enshrined under Article 15 and Article 16 of the Constitutions, read with Article 335 of the Constitution, which mandates to maintain efficiency in governance, efficiency in administration, and every decade, particularly on aspect of Article 15 and 16, when it comes to the reservation policy and the affirmative actions in different, which shapes the politics also by and large across the country. Uh, every decade we have 3 to 4 constitution bench judgments which reconsiders the new issues or the reconsider its older dictum or the older judgments, and in that process sometimes we get constituted the larger bench also. So yes, that's one of the um, uh, key area where I work. And coming to on a comparative level, we have seen the evolution of affirmative action in United States, which is one of the oldest governing constitutional democracy. We have seen the how the affirmative actions in particular based on the criteria of race has evolved, come up, and last year with the judgment of fair admission committee against Harvard, how the Supreme Court of United States has changed the very criteria of affirmative actions. It termed the policy, the admission policy of Harvard University as violative of constitution based on the diversity, and it said that the moment you are using the race as a criteria to for the admission, which is not a constitutionally recognized criteria for the discrimination, because the constitution in its or the US constitution in its original text does not use the word race for the discrimination. But that's not the case in particularly in context of India's constitution has been written much later in 1950, which uses different criterias including gender and children and the place of birth, residence, etc. So it's permissible, but yes, uh, uh, I think the even the reservation policy and the affirmative action plan in Indian context will also be shaped in next decade very comprehensively, uh, and I expect that the some larger bench to reconsider Indra Sahni judgment uh, uh, will be constituted very soon. I see Maratha reservation, the issue of Maratha reservation in context of a state of Maharashtra is one of the such issue where the larger bench can get constituted. It has already been once decided by 5 judge bench of the Supreme Court, but that issue in a state of Maharashtra is still being being debated at the legislative level, at the executive level, and sooner or like it's already pending being considered before the Bombay High Court again. So that's one of the key aspect, and we have a lot of thing to learn from the different jurisdictions. Coming to the comparative aspects, like South Africa, we have a very unique perspective on reservation and giving representation to the different communities, a fair share in the distribution of natural resource, like distribution of the community resources. If we see, and particularly the states largesses which are there, and the and once we see this reservation, there is a very basic debate going on before the Supreme Court also whether it's a fundamental right or it depends upon the discretion of the state. Whether it is a classification for the purpose of Article 15 and 16 in favor of certain communities based on the caste or the economic criteria or different social criteria. Uh, Coming next for constitutional law, there is one important issue which is again pending before the Supreme Court, perhaps a constitution bench. It's about the fiscal federalism aspects, thus limits on the state's borrowing power from the different countries or the international bodies. The center has enacted an legislation, that is FRBM Act of 2003, which limits the state's power to borrow from international monetary or the World Bank or IMF or international agencies. Like different countries have their international agencies which funds the different projects.
So, Ravi, it is impressive that you have been editor at the American Review of International Arbitration. How did this role come about, and how has your experience been?
That was a wonderful opportunity. Well, while I was pursuing my master's at Columbia Law School, being editor of one of the leading journal on the international arbitration and the investment laws, uh, it has set my a deep understanding and influenced me towards exploring the international arbitration also, because being the part of the like one of the prestigious journal from the Columbia Law School, mm, you get the best of the work written by professors and the practitioners across the globe, and then you evaluate and edit those works, and then cross check also in that process that is it correct, the proposition of law or the arguments which the author is advancing, uh, is it backed by the some of the scientific data or the legal proposition which, upon which they are relying, or can it be deduced logically? So in that process it was a great learning experience, and I have learned a lot. And for the wonderful listeners, the it's the blue book citation we follow, and the Columbia Law School is the blue book is being managed by the three law schools, leading law schools of the world, that is Columbia Law School, Harvard Law School, and Yale Law School. So yes, it was a unique experience, and I must say that the one those who go for my master's program at these law universities, they should be the part of such editorial teams and boards.
Wow. Okay. You have been an advocate on record at the Supreme Court of India. What has been the most memorable moment with the judges?
Yes, advocate on record is a huge responsibility before the Supreme Court of India, because these are the category of lawyers who are responsible for filing the cases and managing the cases before the Supreme Court of India. And in that process, uh, yes, the you interact more with the judges. Judges look for advocate on record and not for senior advocates or even the arguing counsel. For any discrepancy or for anything, the judges will be the first one to ask who is AR and where he is. Uh, some of the odd practices of name lending and the AORs not being present in the courts were noticed before the Supreme Court recently, but that has been taken care, because the judges issued a stern warning through judgments, and disciplinary actions also were initiated against some of the erring advocate on records who were absenting themselves. Uh, and yes, the judges are do accommodative mm, with respect to their certain AORs, because the AOs, some of the AORs who are having large number of cases uh, before the Supreme Court, they cannot be remain present in every court or in the simultaneous courts. Yes, but they have a very good robust team also to manage the cases to be present, and the ones required by the judges, the advocate on record themselves make present and assist the courts. And it's a very huge responsibility before the Supreme Court in world of litigation.
Wow. So, Ravi, you have taught at the Indian Law Institute. How has legal education evolved in India?
Thank you for this question, because I think the legal academia is one of the important aspect of my life and journey so far. uh, I have been contributing regularly towards the classroom teaching through articles, to different through different write-ups, by drafting moot court propositions, and getting involved into different uh, presenting my thoughts on in seminars and the conferences being organized by different law schools across the country. Coming back to the Indian Law Institute, I did also my first master from Indian Law Institute, and I qualified UGC NET way back in 2011. So I was eligible to be a assistant professor in the beginning of my career, and yes, being one of the pioneer legal research institute of the country, which is managed by Supreme Court of India, it was a privilege to teach there, to conduct a course on banking and finance law for a semester. And yes, it was challenging. It was challenging precisely because of the audience and the students in the class. Yes.
What advice would you give to young legal professionals who want to become advocate on record at the Supreme Court of India?
The, as far as the practicing before Supreme Court of India is concerned, for a beginner or the for young legal professionals, you have to be very careful. You have to be very careful because here the talent pool is enormous. You have stalwarts, senior advocates, uh, from whom you can learn, from advocate on records from whom you can learn. But in that process, you should not lose your focus and the goal, that you have to mark your presence and make your identity in that with a gradual process and the time. So the identity, obviously, being after 5 years, when you are eligible to write the advocate on record examination, I will say that to qualify that examination is the first step towards your identity before Supreme Court of India. That now you are a qualified advocate on record who has passed the examination, which is being conducted by Supreme Court of India on an annual basis. And there is a fixed syllabus and all those things. But yes, if you are not qualifying the advocate on record, but still you are focused to make your presence feel, or the mark your presence before the judges and in the courtroom while arguing, then also I'll say that the you you should prepare your brief, you should read the file, and because it's the last court, it's the opportunity which you get is very rare and for a very short duration of time to put your words before the judges, so that the judges, it gets clicked with the judges. So in that sense, it requires a lot of preparation, it requires a lot of research, and it requires, I'll say that the in unique American style, it requires you need to practice also before going to the courtroom when you get a chance to address the honorable judges. And so yes, uh, you have to be very focused when with the briefs and with the pages. And in digital era, uh, the judges are also uh, equipping themselves very quickly with the technology. So the technology gives you the advantage. Utilize that advantage to the fullest.
Wow. So let's go to the next round and understand Ravi as a person, Tell us about your family and your formative years.
Well, I come from a very humble and rural background. Being born to a family of teachers, my parents were teacher in the school in Bihar, and but yes, when I was doing my schooling, I did not see electricity. My village had never had the electricity. The electricity reached in my village in year 2005, and coming from there, joining Sainik School Balachadi, Jamnagar, mm, in boarding school, and when I was in class 6, mm, was also very challenging. Going away from the family almost 2400 kilometer and staying in the boarding school, even if the vacation is there, it used to take 3 days to reach back via train to Bihar, to my place. So, but those experiences were life learning that has shaped me, that has challenged me, and I have come across so far. Uh, Having passed my class 12th from Sainik School, uh, uh, being an awardee of best cadet, passing out cadet from the same school, a recipient of Sword of Honor also. I joined law in year 2005, studied in Hidayatullah National Law University, completed in year 2010. Thereafter, I worked as one of the researcher, law clerk come research assistant to one of the judge of the Supreme Court of India. And since 2012, I got enrolled and I'm started practicing before Supreme Court of India itself.
Beautiful.
And recently, I went to Columbia Law School for my higher education in year
Wow.
2023 and returned back and resumed my practice in
Beautiful. So, what
2024.
is hobby or interest which helps you to unwind and recharge?
Mm, during the like life of a litigator before Supreme Court of India, we have hardly holidays or the weekends, except the summer break and the winter break, which we officially get it. So, because in Supreme Court, usually those who practice, the clients travel from different parts of the country. So, generally, lawyers and the advocate on records give them time to come on weekend, so that once they are traveling from different corner of the country, we should give them 2 hours, 3 hours in a long in a stretch, and we should understand their matter. We should, because we are going to represent them before the Supreme Court, and Supreme Court is being the final court of the country. So when the courts are in session, we hardly have weekends, we hardly have time for ourselves. So the motivation is to keep the good work and contribute towards the justice delivery system to the best of your knowledge and the best of your capacity. During break, as a practitioner of law, I generally do not work. We do not take up cases. Relax, recharge ourselves with good readings, update ourselves with the judgments which have come up, important judgments which have come up in last 6 months or throughout the year, uh, which we have not noticed, because media does not report all the judgments. Media only reports the highlighted judgment or the politically sensitive judgments. So yes, that's and I travel a lot. I have traveled to the almost 15, 16 countries during summer breaks and winter breaks. So yes, learning and gaining those experiences are also valuable. and in that process, I recharge myself.
That's beautiful. Okay. Was it book which has book or movie which has left a lasting impact on you?
Uh, in movie from the Bollywood, I will say it's the Guru Dutt's Pyasa, the
Mhm.
classic movie, and the book I'll say it's written by um, Professor. There are many. In fact, if I'll go on subject matters, like in constitutional law, I will say that it's a book written by Professor Akhil Amar, who was also a professor in Columbia Law School and Yale Law School. Uh, he is a great writer uh, and a historian. Constitutional. He writes on constitutional history. He
Wow.
So the words we that made us. That is the title of the book. The words that made us.
Wow. Beautiful. So my last one for your personal journey round. Describe Ravi in one line. It's a googly one.
Uh, Ravi is synonymous to hard work.
Beautiful. So let's put you in the hot seat, the rapid fire round. Your go-to comfort food.
Any homemade food, simple,
Wow. Your favorite color.
red.
Your dream travel place.
I had traveled to New Zealand and explored extensively in my very first international travel.
Wow. You're a morning person or a night owl?
Morning person,
Wow. Chai or coffee?
chai.
And you did well, Raviji. And here's your book, which will be autographed and sent to you. So, friends, it was a lovely conversation having with Ravi. So, all those young legal professionals out there who want to be a litigator, practice at Supreme Court as an advocate on record, and also contribute to being in the legal education. This is the episode. A lot of inspiring. There are 500 plus coffee speakers who share the inspiring journeys. Subscribe, get inspired, and if you want to be featured, visit our website, the Emerging India Forum or LinkedIn page, and we would invite you to continue to our coffee conversations or a cup of coffee. So stay. We meet with tomorrow with another coffee speaker. Thank you.
Thank you. Thank you very much.